I'm sure everybody's heard the terms patent and copyright and trademark and things like that. Tell us a little bit, what's the difference between a copyright and a trademark?
Sure. So I'll start with patents because that's the one people tend to know about. If you invent a new invention, new car, new truck, new chair, new gizmo, that's usually what people think of when they think of a patent. You can patent an invention. If your business has a name, you can trademark the name to stop people from copying the name. And if you come up with some new creative work, like you write the next great American novel, or you write some software code, or you draw a drawing, or you make a painting, those things can be copyrighted. So copyrights protect creativity, trademarks protect names, and patents protect inventions. And that's the 10,000-foot view of how that all works.
Okay. Now, when you're talking about patents, are there certain, does it necessarily have to be an invention or an actual device or a thing that you would get a patent on?
Not necessarily. Most patents are that. They're called utility patents, and that's what people tend to think of when they think of patents. You can also get patents on designs. Way back in the day, the classic Coca-Cola bottle, with the classic shape, that had something called a design patent, where you just patent the shape and the look of the industrial product. The iPhone has a patent just on the shape. So if you have an industrial design for some product that you sell, that's definitely something you can get a design patent on. If you make a new plant, you can get a plant patent on that. Most people don't do that, but that is an available thing as well. So there's three kinds of patents. You have utility patents for inventions, design patents for designs, and plant patents for plants.
Okay. Now, I'm sure you've heard the term necessity is the mother of all invention. I'm sitting there thinking to myself, you're watching TV and you see somebody come up with a product, and maybe it's like a modification of something that you already do, or maybe you're somebody like my wife who can find these regular devices and somehow switch them up and turn them into something that comes up with a different use. What would you do if you have a situation where you take a common product like you have in the house and you say, hey, this is really good for this other thing if I were to make these modifications, and you basically alter an existing design? Is that the type of thing that you would necessarily need a patent for?
You can. Do you need a patent for it? You need a patent only if you intend to make or sell or use this thing that you created. So if you've found some design and you've made an improvement to it, and this improvement really is something new that has never been done before, you may want to consider seeking a patent if you intend to commercialize that product. There's another side to that, and that is, even if you get a patent on this new twist that you've put on this idea or this design that's already existed, you may still need to get a license from the older technology, the person who owns the older technology, before you can actually sell the newer technology, because in a sense, the old technology is sort of built into that new technology, if that makes any sense.
Yeah, I think I understand what you're saying there. If anybody has a question about intellectual property, trademarks, patents, copyrights, you can give us a call. We're taking your calls live at 850-392-1544. Jared, one of the other things I was thinking about, we have a lot of different industries in the area. We have a lot of technical industries in the area. What if you, say, work for somebody and they design a widget, but in their spare time they do their own work, somewhat similar but not necessarily the same work they're doing for their employer? Is that something that, number one, is it allowed? And number two, is that something that you could somehow, if you come up with a design outside of work but it's very similar to what you do at work, is that something that you could put a patent on?
I've run into this issue before, and the rule of thumb is that if you are an employee for a company and you invent anything or you design anything that's very similar to what you do at work, it's very likely your employer is going to try to claim what you have designed as their intellectual property. That's the rule of thumb. And nowadays, people working on their smartphones, on their laptops, oftentimes those things are provided by their employer, or the employer pays for part of the cell phone or pays for Wi-Fi. People who are in the design world or the technology world, it's tough to prove that you designed something totally on your own time, totally with your own stuff, and it has nothing to do with what you do at work. So if you are working for someone and you're in the business of inventions, you should go talk to your employer and figure out what your IP rights are with respect to your employer. That's my suggestion.
Very, very good. So I imagine, we talk about these intellectual property rights, and it really can extend from tangible things and inventions all the way to creative works. I know that Bay County and the surrounding areas, there's a lot of amateur musicians. There's a lot of people that write songs, write music. Is writing an original song or creating an original lyrics for something, is that something that somebody would want to seek a copyright on if they wanted to protect their idea? Maybe they wrote a really good song, they want to send it off to somebody, but they want to make sure that they get compensated for their idea. What would they do in that situation?
So if you're a songwriter, I should back up. There's three different things there. If you're in the music world, the person who writes the lyrics, and the person who writes the music, and the person who performs the song, those are three different people. If they are three different people, those are three different copyrightable works. So it's important to figure out where you are in the musical process and the composition if you're involved in all of that. But you asked about songwriters. So if you're someone who, let's just stick with lyrics. If you're someone who wrote lyrics and you want to try to get a license, you want someone to use those lyrics, you don't have to go register your copyright at the Copyright Office. All you need to do is to make sure you know that you're the one who drafted those lyrics and that you made them. I suggest writing them down somewhere. And then make sure that when you license those lyrics to the person who's going to integrate them into a song or perform them, you get it in writing. If you want to register the copyright, it's because you intend to enforce your copyright rights in some kind of lawsuit.
Right. So tell us a little bit more about your practice. I know you practice in the area of intellectual property law, but what are some of the more common things when somebody's looking for, we always abbreviated IP, but when somebody's looking for an intellectual property lawyer, what are the most common things you typically see and that you typically help people out with in this area?
All right. So the most common thing that happens, if I don't get a referral from another attorney, the most common thing that happens is someone calls up and they have this idea that they're doing something that needs intellectual property protection, but they don't know what it is. So they'll call up and they'll have a business name and they think they need to patent it, or they're not really sure exactly how to approach it. So the most common thing I do is help people sort out what it is they're actually looking for, what kind of IP protection they need. And amongst those different things, trademark law is usually the most common. Usually people who own businesses will at some point in time encounter someone who has a business name very similar to theirs, if not identical, and web traffic and foot traffic will be misdirected to a different business, and they want to figure out, how do we ask this guy or this other company to change their name into something that's not as similar as your own company? That's pretty common, especially in a service industry area like where we're at.
Okay.